Today we will hear a review of Lincoln's Last Trial, the murder case that propelled him to the presidency, by Dan Abrams and David Fisher. Writing for the Washington Independent Review of Books in July 2018, Talmadge Boston said, "For those who wonder why Abraham Lincoln's hold on the American psyche never slips, the answer is simple. The superior wisdom he consistently demonstrated in the political, rhetorical, military, and legal arenas is unmatched and timeless. This assessment is especially true of Lincoln's career as a trial and appellate lawyer in and around Springfield, Illinois, from 1837 through 1860. Bringing new recognition of his courtroom skills into the mainstream, ABC News chief legal analyst Dan Abrams and veteran collaborator David Fisher have delivered a fascinating depiction of Lincoln's last trial. Our presenter today is Sanford Shapiro, senior litigation counsel with Forsyth, Howe, O'Dwyer, Kolb, and Murphy. Please join me in welcoming Sandy to the podium.
Well, Lincoln's Last Trial by Dan Abrams and David Fisher is an astonishing book. And as you'll see, I will give you my evaluation of it. Until I read this book, I always wondered how a down-home lawyer from Springfield, Illinois, population 15,000, and unpaved streets, could have assembled the political clout to become our 16th president in 1860. I mean, there's no TV, there's no radio, there's no, well, there are newspapers, but Lincoln's Last Trial holds the secret of this, and it's a book full of surprises, okay? Thank you. It's a tale of two men. The first, we all know and revere, but the second, a man long forgotten, whose work was largely responsible for vaulting Lincoln into the nation's consciousness. How? Well, Robert Roberts Hitt, H-I-T-T, a court stenographer who was the first to produce word-for-word transcripts. I asked about 6 stenographers in town whether they ever heard the name of Robert Roberts Hitt. No one had. But the New York and Chicago newspapers hired Hitt to make a transcript of the Lincoln-Douglas debates. You know, the debates focused on whether slavery could be pushed into the new territories. The transcripts sold an astonishing 30,000 copies, and it brought Lincoln enormous awareness in the United States. Now, when I was, I think the summer before I went to law school, I read Carl Sandburg's 4 volumes of Lincoln. And when I read this book, I started to wonder, did I miss something in all of those volumes? And I went back and I looked at the very thorough index of Sandburg's books, and the word that Robert Roberts Hitt doesn't appear. And I think he has largely been lost to history until this book came out. Well, let me start by giving you a sense of the year in which all of this happened. Now, the debates were in the fall of 1859. but the 1859 was a seminal year in the United States' history. Let me give you some examples. Oregon became the 33rd state in our country. The Comstock silver lode was discovered. A balloonist traveled 800 miles from St. Louis to, you're not going to believe this, Henderson Harbor. I don't know how many people have been through Henderson Harbor, but you could drive through it in about 6 minutes without stopping and without speeding. And America's first oil well was dug in Titusville, Pennsylvania. Well, now some other things were going on. Slavery divided America. The Supreme Court decided Dred Scott and concluded that slaves could not be citizens. Congress could not prohibit the expansion of slavery into the territories, which was the subject of the debates. And Lincoln left America with some quotable lines. A house divided against itself cannot stand, and government cannot permanently endure half slave and half free. The debates were followed very closely by people, and Robert Hitt, the first word-for-word transcripts, memorialized these debates. Well, what else happened in 1859? Peachy Quinn Harrison was tried for the murder of Greek Crafton. It was two young men in this small town who knew each other. Everyone knew each other. And it was Lincoln's 27th defense of a murder case. I had no idea that I knew he had practiced law. It was Lincoln and Herndon, a two-lawyer firm in Springfield. And if you read this book, he describes the office. I mean, it was like a one-room dump. And they rarely spent time there. But Lincoln, of course, was a big man in Springfield, 6'4", and he wore a 15-inch high hat. And he used to carry his legal papers in his high hat. But the book is very personal about his life and his thinking, and Lincoln got Hitt to give daily copy with an Esterbrook pen, according to the book. Before that, appeals, for the attorneys who are here, records on appeal were created by the memory and notes of the lawyers. And they trusted each other to make an accurate statement for the appellate courts. It's hard to understand how today everything is very exhausting when it comes to putting together a record on appeal, even to our own fourth department here, all of the appellate divisions. But then the attorneys, who were very collegial, very considerate of each other and respectful, they put together records on appeal from memory. Well, the trial is surprising for the collegiality of the attorneys and the respect they showed for each other. There were differences in the law back in 1859, and when arguments were held on motions or objections, all of the attorneys would argue. There were 5 attorneys involved in the case, 3 on the prosecution and Lincoln and Herndon on the other side. And even in summations, the prosecution would start, 2 or 3 of them would speak, and then Lincoln spoke, and then Herndon spoke, and then Lincoln spoke again. And this was of course, a jury trial. And Lincoln was highly regarded as an attorney, but within a relatively narrow sphere nationally until the debates. And then to take on this criminal case This was an argument between two young men. One of them was a good-sized fellow, and the other was quite small, peachy Quinn Harrison. And at the trial, Lincoln would talk to the jurors like they were his friends. He had a line that always intrigued me, and it was, how many legs does a dog have if we call his tail a leg? You have to think about that. And he said, 4. Just because you call a tail a leg doesn't make it a leg. And there's a lot of thought that goes into that. It was one of my favorite lines. Well, in chapter 3 of the book, the jury selection is taken up at length. And you get a sense of Lincoln's trial strategy and his very down-home talk to the jurors. And there were some differences, as I say, in the law at that time, and they applied particularly in this case. First of all, the defendant could not testify in a criminal case. It had to be all other witnesses, but today there's always a question whether the defendant will testify and make himself open to cross-examination. Well, the second change, which was substantial and a big part of this case, was self-defense, what we now call stand your ground. It was debated then. It was an emerging concept, and it still is in many ways today, that we argue about whether the accused had the right to self-defense, and in this case, Greek Crafton made it known that he was going to give Harrison a beating. And they met in a store, and Crafton began wrestling around. As I say, he was a much bigger man, but Peachy had a knife, and in order to escape, he slashed Crafton across the abdomen, and Crafton died about 3 days later or so. Well, in those 3 days, he made a lot of statements about his feelings toward Peachy Harrison, and he opened the door to what are called dying declarations. And again, an emerging issue in the trials of that time, and in some ways it still is. Dying declarations means that the victim realized at some point that he was on his way out, and he would say some things that the court decided were honest because he was facing his maker and knew it. And query, could those statements come into evidence at the trial? Well, that was a lengthy process in the trial of Harrison, and a trial that the judge, Judge Rice, at that time, very knowledgeable, as it's described in the book, he at first wasn't sure about whether those remarks by Crafton could come into evidence, because they, in some ways, exonerated Harrison, because Crafton had really started all of this, and it was known that he was going to have to do with Harrison. Well, in that, what the judge called the confrontation of giants, Lincoln for the defense and the attorney, the lead attorney for the prosecution. And it's chapter 11 in the book if you plan to read it. But Lincoln's trial strategy is analyzed in considerable detail. And I'm not sure how the authors who had access to the transcript, how they could know, because they say that everything that they put in the book was right out of the transcript and the newspaper articles, but they give impressions by the people that were involved in the trial and how they knew those things and their thoughts, and especially Lincoln's. Lincoln would finish a long day of trial and then go out for a long walk by himself and consider what he had to do. And as I say, his trial strategies on these issues were just brilliant. And his argument to the jury and to the judge, there are long arguments that go on when the jury's taken out of the courtroom. The courtroom, incidentally, was jammed full of people every day, people sitting on windowsills, and it was a matter of intense awareness by the people of, beyond the Springfield. And in chapter 12, for those of you who will read it, at pages 216 and 219, Lincoln's arguments on these issues were, as I say, dramatic and very, very strategic. He was quite a lawyer. Finally, I say the book is full of surprises, and I want to tell you that apart from the information about HIT, the closing paragraph of the book is the biggest surprise of all. It's short. I'm going to read it to you. Page 287. At some point, HIT's original transcript of the trial was bound with a ribbon and put aside, only to be discovered in 1989 in a shoebox stored in a garage of the Fresno, California home once owned by Quinn Harrison's great-grandson. And from that meticulous transcript, so perfectly stored over the years, we're left with the final direct link to the last great trial of Abraham Lincoln's legal career, an event that helped propel him to the presidency. So there's the answer as to how Lincoln came to the attention. A two-lawyer firm in Springfield, Illinois, to produce a president is just unheard of it, even then. And the transcript I just learned from someone who spoke to me before we began is available. There's a historical society that has a copy of the trial transcript. Of course, the debate transcript, that was a book about which I have read some years ago. And the surprises that are in here are, as far as a trial back 160 years ago, are very revealing. And when I was somewhere in law school in Syracuse, I used to go to a bookstore and rummage around an old bookstore downtown, and I got for probably $1 or $2 a copy of Bishop's Criminal Law from 1858. And to give you a sense of how the law was being changed at that time, the slavery, of course, slaves were not citizens and not human beings. They were property. And there's a long chapter in this book about whether the masters could work a slave to death and be accused of a crime. Now, there were different rules in different states, but it's very revealing about the depth of the slavery problem that America was dealing with at that time. Whether a master could murder a slave, whether a master could do a lot of other things to slaves, both men and women, or work them to death. So it is a very revealing section, chapter in this book, Bishop on Criminal Law, the year before 1859, that reveals the depth of the problem of slavery. It's still with us, and it's still an influential segment of United States history that's never going to go away because it was a different time. Well, that is pretty much the Lincoln's last trial, and I recommend it to anyone. It's not that, it's about 300 pages, but it really moves very quickly because you get a sense of a man who was just a genius as a trial lawyer, let alone president of the United States, and one of, I think, 4 who were assassinated. There was Lincoln and Kennedy and McKinley and Garfield. Yes, Garfield. It's the last book I reviewed here. A wonderful book. But it all comes out in this trial, and it's a turning point in American history, I think, because obviously the assassination of Lincoln, but also the debates and the Civil War, needless to say. So with that, if there are questions about it, I'll